Maurice V. Bondi, out of the First Circuit. This guy, and I don't know, maybe he's a bad guy, maybe not. He's got quite a few domestic violence arrests and some charges and a really bad police report, but no convictions, and the charges were dropped. And maybe there were some pending ones during this, but I don't think so. This case is in the context of adjustment of status, discretionary relief, an immigration judge denying based on what was said in the police report. And the First Circuit is again saying you can't do that. Quote, a police report, absent a conviction, must be corroborated before the agency may give the report substantial weight in denying adjustment of status as a matter of
Nice.
discretion. End quote. So if your guy comes in and is denying what's in the
Yeah.
police report and they don't have anything else, like they can't really rely on it. And by the way, that's coming from the BIA's 90s decision in matter of Eric Gwynn. So really that should be a nationwide rule, even though the current BIA has amnesia about old decisions as if they don't exist. But First Circuit really beating this
You never
drum
know what kind of crazy
on
stuff will be in there.
discretionary adjustment of status.
You never know. Yes. Is USCIS a court adjustment or is it applied to USCIS as well?
Yeah, technically this applies to USCIS in the First Circuit too, but good
Yeah.
luck there. They don't act like they're a court or lawyers because they're not. But still, this should bind in the First Circuit and would be a absolute reason to appeal to the
Mhm.
AO if that in the First
Yeah.
Circuit for sure. And it should be nationwide. Again, matter of Eric Gwynn. The BIA that the First Circuit is in part
Yeah,
relying on.
I've seen some police reports where just cockamamie, wild things that are in there, like have, you can hear their inconsistencies, and it's, oh man, this is going to be some nonsense if they actually there's.
But you don't even need that. The First Circuit's saying if it's not corroborated and you deny it, it's not worth much. And that's a big
Wonderful.
deal.
Well, that's some good news for honest lawyering on the government's part, honest adjudications.
Yeah. And it's, by the way, that's the case in all law.
It's like hearsay or
We
something.
thank the circuits. We thank the circuits for these scraps, and people are like, oh my God, that's great. It's literally the law in everything. Of course, you can't rely on hearsay documents without
Yeah.
corroboration or without testimony in criminal law, in civil law. By the way, two people arguing about $20,000, like you can't get this
Yeah.
in. And isn't removal and a green card a little more important than 20
Yeah.
grand? I think there needs to be a whole reset, and that's about marketing and reminding America that immigration matters and that these people have rights. But so that's a bigger conversation.
Thanks so much.
That's
So,
only
like,
two.
okay.
We had a side discussion
Oh,
about
okay, that's
habeas.
okay. So yeah, what do we got next? We have time. We have no rest today.
Amos, the Attorney General out of the Third Circuit. This one on October 1st. This one is just so much, and I'm not going to get into everything. It's just there's so much going on in this case. What I find it most interesting for is the discussion of particularly serious crime and convention against torture protection. There is a budding circuit split happening about the matter of NAM analysis required when you're going to deny asylum and withholding of removal, especially when you don't have an aggravated felony. Or if you do and you don't have an automatic 5-year imprisonment, is it a particularly serious crime for withholding of removal, for example? And it's a 3-step analysis. And the first step is the conviction of the type and nature that would make it particularly serious. The majority of circuits, and now the Third Circuit agreeing, are saying that's like the categorical approach. You can't look at the facts of the conviction, step 2, step 3 of the matter of NAM analysis, if the conviction itself, if the statute isn't of the type that's making it particularly serious. What is of the type that's particularly serious? It's usually violent stuff. After that, it gets mushy. This was conspiracy. What was it? Conspiracy to, I think, to commit immigration fraud, something like that. And the Third Circuit is saying, let's Section 371 federal conspiracy to commit a 1542 offense. Some conspiracies are more serious than others. The Third Circuit talks about a conspiracy to steal a book of as not being that serious. And then the Third Circuit is saying you need to go to the underlying elements of the underlying offense. But this is what's really important to me. Quote, a conviction for a conspiracy to commit a substantive offense does not require proof of all of the elements of the substantive offense. It does not even require proof that the defendant committed any overt act in furtherance of the offense. End quote. Restated, the Third Circuit is saying to get a conspiracy conviction, you don't have to show that bad of things happened. So I don't know. That quote to me supports the argument that a conspiracy statute is never a particularly serious crime, at least federal conspiracy. It's interesting. I think the Fourth Circuit would beg to differ if I'm remembering correctly, but pin this in the ever developing areas of conspiracy, criminal, and particularly serious crime stuff. And I know that I'm getting real into the weeds. And then there is some Convention Against Torture stuff in where the Third Circuit is saying, look, BIA, you can't just deny based on your belief that their predictions of what's going to happen to him in the future is speculative or because he didn't know his idea. That's the nature of it's all about what's going to happen in the future. The future is always speculative by definition. What are you doing? And so there's a lot of recent BIA decisions that would indicate otherwise. So good on the Third Circuit. And also even the third saying you don't even have to know the identity of the perpetrators to get cat protection. They could be wearing masks, explains the Third Circuit when they attack you.